For our second panel, we're moving on to the topic of corporate crime, which is probably very familiar to you as general counsels, but it's changing significantly with a much closer intersection between multiple areas of policy. And to open up this topic, we're joined by three speakers. On my immediate left, Marshall Miller, Principal Associate Deputy Attorney General of the United States. He's involved with oversight of multiple Justice Department components, including, among others, the 94 attorneys' offices, the National Security Division, the Criminal Division, and the Department's law enforcement business. In the middle, we're joined by Karen Patton Seymour, who is a partner with Sullivan and Cromwell, where she leads a multidisciplinary practice. She recently rejoined the firm from Goldman Sachs, where she was Executive Vice President and General Counsel. And on the far end, Mike Driscoll, Senior Managing Director with FTI Consulting, where he leads cybersecurity investigations and works with clients as part of enterprise risk. Previously, Mike was Assistant Director in charge of the FBI's New York office. So, Marshall, I'd like to start with you and a speech you gave in September where you said, national security laws must rise to the top of your compliance risk chart. And that was to an audience of compliance officers. For the audience we have here today of general counsels, how should they go about making that happen?
Well, I think to start with, it's really all about assessing the risk environment. That's really often what compliance begins with. Where do the risks lie, and then how do we design a program to mitigate those risks? And what the message that we're trying to send to corporations across the country, across the world, is that what we're seeing from our vantage point at the Justice Department is an increasing intersection between national security risks and corporate crime. And so we want folks in the compliance departments and boards of directors and the general counsel's office to be looking at across their lines of business to see whether those national security risks are present. We're seeing that in our enforcement actions. So when I was last in the Department of Justice back in 2014, 2015 at Main Justice in the Criminal Division, really we weren't seeing a whole lot of national security elements to our corporate crime practice. Now, over the last year, about half of our significant corporate crime resolutions involved violations of national security statutes, ranges across sanctions, export control, money laundering, even financial support for terrorism. But we're seeing those more and more. There were double the number of such actions thus far in 2023 versus 2022, so it's a growing trend. And to come back to your question, I think what we're expecting of companies is that as they start to see the same thing, they need to be assessing that in reviewing how their compliance program should respond to and mitigate the most significant risks out there.
Karen, let's turn to you. As a former general counsel, how would you go about operationalizing this national security lens on corporate crime?
Well, I think as Marshall said, it really is about risk assessment. And so I think you want to utilize the current structures that you have in place. Hopefully you have a robust compliance function already in place. When you think about many of the risks and many of the questions that arise, there are really many of the risks that you may already be thinking about, but you may not be thinking about them through a national security lens. So if you look at, for example, the Lafarge case, paid close to $750 million penalty for their bribery of officials with ISIS that they were prosecuted for under terrorism, aiding terrorism. And so you could look at that also as an FCPA case, and hopefully you have controls for that. Now, I'm not suggesting that you just treat it as business as usual. I think you do need to do, as Marshall said, a very thorough risk assessment to see what are your risks, how could you be contributing to national security concerns and tightening them up, as Preet suggested earlier this evening, you may want to think about having somebody give a second look at your compliance program. Maybe there's things that you've missed, and I think the pronouncements that we've seen from the department, it's frankly quite scary, I think, for all of us to hear what Marshall just said about how much the department has changed in just a few short years. So I think it's a time to take a deep look at your business, at where you're doing business, at your customers, at your counterparties, and try to see if there are things that you need to do to better combat these risks.
So it sounds like this risk matrix has become a lot more complicated. These used to be in separate buckets, or at least treated as such, right? Anti-bribery, money laundering, sanctions. And now you have this national security element that brings them all together. Mike, what are you hearing from FTI clients about how they're approaching this?
So I think in a broad brush, there's three main approaches they have for it. The first is generally the desire to be a good corporate citizen, right? We want to get this right. The second is, and you heard from the list that Marshall touched on, it's a complex environment, right? There's a lot of regulations in this space. There's a lot of different issues that impact what is compliance. And to go back to a question we heard a little earlier, there's some concern of how do I get this right? How do I avoid an issue like we saw with SolarWinds? And if in your firm, if your CISO didn't come into your office when that announcement came out and say, what happened? The shock, I think, is clear. We heard it from across the security industry. This is surprising that they actually named a CISO in this product. It's not the first time we've seen a CISO called out for activity, but each time that happens, it's breathtaking to the industry. And I think it can be a great thing, and I hope it's not a chilling thing, and that was the question earlier, but I think it can be that opportunity to say, hey, how do we get this right? How do we do this better?
And does it call for some new level of expertise on national security issues for people who've been trained in all those traditional areas of law, and now they've got to look at it from a different perspective?
I think it's more, and we've heard this touched on a couple times, I think it's more about understanding what are the risks to the organization, what are the risks that have been previously identified impacting national security. I don't view this as anything new. I think it's more about putting it in the right box and being on top of it.
So one of the most complicated areas over recent years, and one of the most active areas, has been sanctions. And Marshall, your boss, Lisa Monaco, said recently that sanctions are the new FCPA. Can you explain what that means?
Sure. I think it gets at a lot of what we were just talking about. I think the idea that I think Lisa was trying to get at was that just as companies 15, 20 years ago pivoted towards, and any company really that was operating internationally, pivoted towards standing up compliance programs to address corruption, international corruption, and the FCPA statute. So as sanctions risks, in this case, other national security risks are becoming more prominent, companies need to turn their attention to that as a compliance risk and as something that they need to turn their compliance programs towards in the way that we saw companies do in the FCPA space. I think here I want to highlight one other feature that's part of what we're seeing, which is I think sanctions and export controls and things like that, statutes like that were, I think, front of mind for certain companies, certain industries over the last decade or so. If you're in the financial industry, I don't think sanctions are anything new to you. If you're in the shipping industry or the export-import industry, export controls also are not new. But what we were starting to see was these kinds of violations in industries that you wouldn't expect. So we had a big resolution earlier this year, over $600 million resolution, a guilty plea of a subsidiary and a DPA with the British American Tobacco Company. I don't think anybody would say tobacco industry or agriculture equals national security risk, but that's what we saw. We saw the BAT company, a very venerable company and one of the largest tobacco companies in the world, engaging in sales through a subsidiary in North Korea, and the proceeds and the activity in North Korea and the money being made in North Korea going straight to the North Korean weapons program. So agriculture is one example. Cement, to the Lafarge company example that Karen mentioned earlier, who took a guilty plea to material support for terrorism. Again, cement, the cement industry, largest cement company in the world. You wouldn't necessarily see that as a national security risk area, but we're seeing that. We're seeing it more in industries that you wouldn't expect, and that's what I think Lisa's getting at, is just like every company that operated internationally back 10, 15 years ago pivoted to say we've got to have an FCPA compliance program if we're going to mitigate the risks that are faced by our company. That's what I think the government wants companies to be thinking about: the sanction space, the export control space. I'll give you one last example of an unusual national security risk. Just over the last year, we've done a number of takedowns, and we've sent out a number of compliance alerts relating to North Korean IT workers who are taking freelance IT jobs at companies across the world. They're using various ways to disguise themselves, but they're entering these companies and doing two things. One, they're earning proceeds, which they're then, some of which they funnel back to the North Korean government, but even scarier, they're insider threats. And we've seen folks get hired by companies that don't know that this freelance IT worker is actually working for them out of North Korea, but is masking where they are, working freelance, entering their systems, and either stealing technologies or trade secrets, or just providing an entry point for potential cyber attackers. That's a scary proposition. And again, when you hire an IT worker, you're not necessarily thinking this is a national security risk.
Sure, and I mean, it's a complicated area anyway, sanctions in particular. And Karen, I wanted to get your take on this. It's not just that this has become a major tool of policy for governments around the world in response to geopolitical crisis, but it's also multiple lists, different policies across companies. If you're a large multinational organization, how do you go about keeping up with it? You probably need a sizable staff and a lot of resources, don't you?
You definitely need a sizable staff. If you're a large financial institution, you have a sizable staff that is doing this work simply because the checks have to be done in all jurisdictions. You also sometimes have conflicts of laws between different national laws that you may have to obey. And so there can be some very tricky issues about which law will prevail depending on what the business is, and that can be very complicated. But I think one of the hardest things is, as Marshall said, this applies obviously to all companies. And so there may be companies, think of startups, think of Zoom, for example, that overnight became, huge. And a lot of these companies don't have the infrastructure, they may or may not have the sophistication to have built up quickly. And I think that's where, GCs of those smaller technology companies or startups need to make sure that they are helping to get in place to ensure that they're complying with these laws, because the sanctions apply to them just as much as they do to the financial institutions. I think the other thing I would mention that I hear about, the real challenge, is with sanctions evasion, there's an increased usage of front companies. And so knowing who is behind a front company can be very time consuming. And you really can't just look up a company and it doesn't hit your list and say it's okay. You really need to, again, you have to do a risk-based assessment, but understand, who is behind that transaction. And so that, depending on, there can be red flags. You could be in certain parts of the world, for example, but that can be hard on companies that haven't traditionally devoted enough compliance resources to do the job.
And Mike, when you're advising companies on their enterprise risk, where are some of the areas where they tend to fall short, and what are some of the steps that you're advising them to take?
We always fall back to the basics. Fundamentals of due diligence, knowing your client, conducting assessments. Don't go it alone. Speak to the experts who are out there. There are plenty of resources out there to help you get through it. But probably the most important of all of those is it's got to be uniform through the organization. It's got to be up to the top of the organization and back down again. You can't have a sound policy for compliance You can't have an outstanding practice and procedure if it's not communicated to the basics of the organization. You could have the greatest compliance process in the world, but if your IT structure, the folks who put hands on the keyboard, can't make that work because it's just not technically possible, then you're missing the boat. So it's that constant communication up and down the line.
And constant monitoring. Export controls have become a major tool of policy in recent times, and the department, Marshall, has been involved in something called the Disruptive Technology Strike Force. You've had that now for a few months. Can you tell us what you found and what you've been doing?
Sure. So in keeping with, I think, our identification of the correlation and overlap between corporate crime and national security, and I think we talked a little bit earlier, Preet and others were talking a little bit earlier about artificial intelligence. I think that's a good example of the kinds of technologies, the disruptive, what we think of as disruptive technologies, which if exported to nation state adversaries or other bad actors could be weaponized against our country, could some of the bad outcomes that Preet referenced earlier, in addition to the potential useful outcomes of that kind of technology, is something that we worry about. There are a lot of export controls around whether it's AI type of data sets or tools, or whether it's electronics, microchips, and others that can be used to create weapons. We've put together and stood up the 14 different task forces in major metropolitan areas around the country in an effort to work with our colleagues at the Department of Homeland Security, the Department of Commerce, that's our co-lead on these task forces, to really go after folks who are subverting these laws, circumventing these laws, and sending those technologies overseas to dangerous places. This is an area where I think the department views our private sector colleagues sometimes as folks that we investigate, but often as victims, as witnesses, as folks that we need to work with every day to try to protect our country. Certainly in this space is an example where we're out doing outreach in each one of those task forces to key manufacturers of those kinds of technologies, folks who otherwise engage in business associated with those technologies, to raise awareness of some of the concerns that we have, what we're seeing, share intelligence wherever possible, so that those folks can be eyes and ears for the misuse of disruptive technologies or the mis-export of disruptive technologies, and help them look out for things, just to use again that North Korean IT worker example, making sure that we're getting out some of the things we're seeing so folks can look in their own companies and see if by chance they too are a victim or a target of that kind of national security activity. So we're trying to lean into putting out more and more of what we call quad seal compliance alerts. We say quad seal because it's usually 4 different departments that work together to identify the latest intelligence on what the threat is, and then try to spit that out to the private sector so folks can take appropriate action from a compliance perspective and from a protective perspective, so that we're sharing that. We're trying to be partners with the private sector in that regard.
And it sounds like this is probably an area of international cooperation as well, because you're trying to track these technologies through other countries and ending up with bad actors.
Yeah, absolutely. And we've been working with the OECD on trying to ensure that they're thinking about these matters, and working with OECD member countries to stand up similar, whether it's task forces or whether it's just making sure they have the legal and infrastructure in terms of having the right laws and regulations that match ours, so that we don't end up with only the US trying to control these technologies. It's definitely a multilateral game.
Mike, you're a cybersecurity specialist, and that's what you do at the FBI. Where does advanced technologies and theft of technology figure in the list of cyber threats? Because there's a lot of talk about ransomware and business email compromise, but this is an important one as well, isn't it?
It is. If we were having this conversation 2 years ago, you would have asked the same thing, but we would have focused on blockchain and we would have focused on Bitcoin. Now it's on the AI question of how is that going to make this harder? we've seen it go both ways. It's being used to make organizations better, make them stronger. There are concerns about data privacy and whether there's spillage and how it's applied across a network, all valid questions right now. But we're also seeing it utilized for financial crime. It's been turned around very quickly to generate phishing emails, when we used to be able to look at a phishing email and say, well, this is clearly fake because the language is off or the punctuation doesn't make sense. And AI will correct that immediately. So we're already seeing that in use today.
And in this arms race, do companies have any hope of keeping up?
They do. The trick is staying on top of it. It requires a robust effort to understand what the technology is. It requires, again, don't go it alone, work with the experts. And there are tools out there to get you through that process.
So I want to turn to some topics specifically related to corporate behavior. Self-disclosure has been something that I think the Justice Department has been pushing for a long time. I know doing compliance events 10 years ago, it was a discussion point, but you've introduced new incentives. What's the thinking behind that, and
Sure.
What have been the results?
Well, I think as we were thinking about things like voluntary self-disclosure and the overall corporate crime program at DOJ, we were very focused on really three elements. Consistency, one thing that I found when I was in private practice and within the department was that you often would get very different approaches to corporate crime issues in different parts of the country, different U.S. attorneys' offices, different components within Main Justice. So consistency. Transparency, trying to tell people what we're thinking. Preet mentioned earlier, we put out a lot of different policies, put out a lot of different, had a lot of speeches, appeared at events like this one a lot to try to explain what we're thinking. The idea being people should know. People should know what we think about compensation programs, which I hope we'll get a chance to talk about. People should know what we think about what the compliance risks are. And then finally, predictability. That's especially important in the voluntary self-disclosure area. If you don't really know what you're going to get if you voluntarily self-disclose, it's pretty hard to make the decision, which is a tough one, to do so. So we wanted to make it much clearer what is expected of a company that steps up, owns up, and comes in and self-discloses, and then what the corollary or the outcome would be, assuming they do the other things associated with voluntary self-disclosure, like cooperating with the investigation, if there were ill-gotten profits or gains, disgorging those, turning over, and this is critical to it too, turning over and information about evidence regarding individuals who might have engaged in illegal conduct. And then what's the result? What do you get at the back end? And so what we've tried to do is make a uniform policy. It can be tweaked a little from component to component, but there's some baseline necessities of every single compliance program, every single voluntary self-disclosure program at the Department of Justice. All of them are published online. All 94 U.S. attorneys' offices have the same program. And there's clear explanation of what you get if you voluntarily self-disclose at the back end, if you do all those things that I mentioned earlier. So that's the idea behind the predictability. And our view is that we think that there are many companies out there that want to come forward and do the right thing, but it's hard to do so when you're handling your obligations to your shareholders when you don't know what you're going to get out of it. So that's the idea, and that's why we've been leaning into it.
So I want to turn to Karen on this one. So Karen, in your experience, what goes into the decision about whether to self-disclose, and is the kind of case that Marshall just made likely to be convincing?
Well, I think the department coming out and being more transparent and certainly more uniform across its offices is a very much needed change. I think there has been real inconsistency. But I think you have to step back with a little history. And I think many of us who have been doing this kind of work for a while have seen many times when there's voluntary disclosure, the company ends up just getting creamed with massive fines and kind of awful dispositions, at least from the corporate standpoint. And there's questioning from senior executives, from shareholders, like, why did we do this? We didn't have to. Why did we make this decision to report? And it just ended up now with hundreds of, millions of dollars of penalties. Was this really necessary? And I think the changes to the program where there's an opportunity to get a declination if you voluntarily self-disclose and you cooperate and do all the other things that Marshall said, means it's easier to help explain why that's a good outcome. So if the department going forward lives up to its promises, and I hope and expect that it will, that will be easier for the decision making at the front end. But I can say that, having been a part of conversations with companies that didn't self-report and nothing ever happened to them, and a part of many companies that self-reported and still had very, very serious consequences, it sometimes can be a very hard sell. So I would say it's a little easier right now that we've given, the speeches and the like can give a little more certainty, but I think there's a lot of people who are still a little skeptical that self-disclosure is the right thing. I would add a caveat on a couple things though. One is that for financial institutions, they're often required to self-disclose because they have suspicious activity reports that they have to file. And the department has a big caveat that if you are required to disclose, guess what? You don't get the credit. So I don't know if Marshall can speak to how it is for financial institutions and other institutions that have mandatory disclosure. Where's the carrot for them? I'm not sure really how that works, but it is one of the challenges. And I think the other one, if I can just say, is the experience we see with the ABB case. In ABB, those poor guys, they call up the DOJ to self-report, they schedule a meeting, and what happens? Before the meeting happens, there's a report and a leak in the press. No voluntary self-disclosure credit given because they didn't get all the facts out there. Now, Marshall may have more to say that. I wasn't involved in it. I just read about it, and I'm like, oh my God, you gotta, you set up the meeting, and if you have something the day, that they propose, you better change your plans because you gotta get in there fast, so.
Yeah, I think if you read the resolution documents, you'll see that they got quite a lot of benefit to having done just that, and they got credit for the fact that they had shown their intention to self-disclose and got quite a large reduction in the penalty because of that. So I think they were the beneficiary of, I think, an effort to reflect that decision to voluntarily self-disclose, even though they didn't formally qualify.
Get your questions ready. We're going to keep going here on the stage, but if you have questions, just raise your hand, wait for the microphone. Sticking with this theme of self-disclosure, so the Justice Department just recently came out with a change in policy related to mergers and acquisitions, which was pretty interesting. It gives companies some leniency if they buy a company and then they discover that it's got problems. Why focus on that area of M&A?
Sure.
Marshall?
Well, I think first, this is a little bit different, right? So the acquiring company here actually, in this scenario where there's a transaction, the acquiring company buys another company and discovers during due diligence or post-acquisition integration diligence that there was illegal conduct and discloses it. The acquiring company actually was not involved in the misconduct, right? It's essentially a whistleblower. And so we felt that it's important to reflect that whistleblowing, the fact that that's their posture, through being crystal clear about the fact that in such a situation, those folks would qualify for the voluntary self-disclosure credit. Now, in that case, we felt that the appropriate voluntary self-disclosure credit for all folks in that scenario would be a declination, to Karen's point. I think we thought the clarity of that and the predictability of that would be helpful for companies. We also thought it would incentivize the kind of due diligence, because there is a timeline on it, although that timeline can be waived by prosecutors if they think it's overly onerous. but there's a timeline of having within 6 months of the closing of the transaction, making the disclosure, within a year remediating fully whatever the problem was. So what it incentivizes, we think, in the M&A space is the kind of due diligence that we think companies should be doing to try to unearth misconduct at a company they might acquire or take some other merger activity with respect to, and bring forward what they found rather than say either having an incentive to not look that hard or have an incentive perhaps to Karen's point, not bring it forward and just decide they'll take their chances. So that's the idea behind it. We think to one other key point here, one of the purposes of voluntary self-disclosure, of course, is to incentivize corporate responsibility. But from our perspective as prosecutors and as the Department of Justice, the other key element is individual accountability. We want to prosecute, it's our job to prosecute those who would engage in significant white-collar criminal conduct. And we think by incentivizing, particularly in this case, a corporate whistleblower essentially to come forward, identify those who engaged in white-collar crime so that we can then go after the actual bad actors and hold them accountable, we think is in everybody's interest. And so that's the general theory and thesis behind that policy.
So Mike, I want to turn to you on the topic of M&A due diligence. It seems like it's become more complicated because of some of the risks that are involved now. Cybersecurity risks in particular, you may buy a company that you find has shoddy practices. Maybe they've already been breached and you only discover that after the deal is done. So what are some of the things that you've come across in your work advising companies on M&A deals?
So the trick there, I think, is something touched on before. It's getting companies to realize that compliance can be profitable. So having these mechanisms in place in advance, to think about this beforehand, and to not be trying to build the plane while you fly it. That doesn't always happen. It's always a challenge. In those instances, we find companies can react quicker and get on top of this and meet the kind of deadlines Marshall's talking about. Where we find they fall short is not planning in advance. Then it really takes that structured, focused approach by a corporation to make sure that if you're going to go down this road and you haven't built out this policy in advance, you haven't tested it beforehand, that you're taking the time, once you've entered this space, to figure out what's wrong. Have I found everything possible that I need to know in this situation? And again, don't go it alone. Engage the experts at the department to talk about, what do I need to worry about in this space? What are the regulations that might negatively impact us?
Do you think the new policy from the Justice Department will incentivize more due diligence after the deal is done?
Encouraging it before?
After the deal is done, after the acquisition has closed, does it call for more diligence at that point in case you can uncover things that otherwise you wouldn't have seen?
I think it does, particularly because they're highlighting the voluntary nature of the self-disclosure. You've highlighted it. They've made it clear that it's a limited time frame. So it requires taking the time to understand that policy and know that they're taking it seriously. And we're seeing that through their actions, right? The department has assigned in the past couple of weeks 25, I think, new prosecutors at DOJ, if I'm right, Marshall, were assigned to look at these kind of issues and focus on just this compliance. So they're taking it seriously. I think it falls to us in the private sector to take it just as seriously.
Marshall, I know one area you were keen to talk about was compensation, and
yeah.
You have been using data analytics in the department to analyze compensation structures. Why focus on that area, and what is it important for our audience of general counsels to understand about this?
Sure. Let me just go back to one more thought on the M&A policy that I just want to be crystal clear about. Is one thing that our prosecutors will, of course, be looking for is any non-bona fide transactions or transactions that would look like someone was trying to sort of launder out some criminal conduct. I mean, that's going to be a critical element, and as you look at the policy, is a critical component. That is, that it be a bona fide transaction, arm's length, and for business purposes, as opposed to some effort to avoid liability. Coming to your compensation question. I think here again, the effort is to be transparent about what we were already seeing in the work of our criminal and national security divisions in terms of the way they evaluated compliance programs, which is one of the ways they think about how to resolve with a company where there was illegal conduct. They look at the compliance program as one of the factors in determining what the appropriate resolution is. I think appropriately, our prosecutors were already thinking about what does the compensation program reward? Does it reward risky behavior? Does it reward compliance-focused and positive compliance behavior? So we thought it critically important to make sure that all folks who might encounter the department know that. They know that that's a part and a significant part of what we're looking for when we evaluate compliance programs. So that was job one, transparency. I think job two is trying to incentivize what we think is an important element of a compliance program, but sometimes gets short shrift. And that is, how does the compliance program think about incentivizing compliant behavior and disincentivizing risky behavior? We want to make sure that in an effort, as compensation programs of course do, to promote profit-making behavior, it doesn't promote overly risky behavior and doesn't undervalue compliance-related and positive compliance behavior. So that's the idea. And then more recently, we put in place a pilot program that we think tries to put our money where our mouth is. So there's sort of two elements to the pilot program, which is being run by our criminal division. So every resolution with a company that the criminal division is entering into for the next 3 years will include an element where they work with the company on a bespoke basis to ensure that that company's incentive compensation program has elements that promote compliance positive behavior. What that will look like will be different in each case. You take a look at the policy and you'll see that that's already been entered into in a couple of our resolutions recently, the Albemarle resolution for one. The second part of our pilot program is actually where companies have the ability to engage in either clawbacks or withholding compensation and then ultimately not paying incentive compensation. And they do so, they exercise that program. They'll get a reduction from the otherwise applicable financial penalty associated with the resolution of the amount that they clawed back, so that essentially it's a double reward for the company that does the clawback. They get the money back. If, say, they paid $10 million in compensation to somebody who engaged in wrongdoing that enabled them to get that compensation, they'll get the $10 million back, and they'll have the penalty reduced by another $10 million. So it's certainly in the shareholders' interest. And then understanding that compensation clawbacks can be difficult to achieve, we've included in the pilot program up to 25% that you can get if you're in the process of trying to claw back previously paid incentive comp or otherwise withheld comp, but haven't yet been able to achieve it. So I think the purpose here is not only to take action with respect to companies that are already in the government's crosshairs, but also to incentivize folks like the folks in this room to take a look at your compensation programs, as Preet mentioned earlier, to say, do we have a fit-for-purpose compensation program? Does it do the things that I was talking about and that some of that we've been trying to incentivize folks to do from a positive compliance promoting behavior standpoint? And does it have a clawback or compensation withholding program that will enable the company to put its best foot forward as its compliance program is being analyzed and take advantage of the pilot program?
Karen, I want to draw on your experience from Goldman Sachs here, because compensation was a big discussion point after the 2008 financial crisis, with the widely accepted view that the compensation structures at some banks and financial institutions had led them into trouble. People were incentivized to excessive risk-taking. Following on from that, what do you think we've learned about the hallmarks of a compliant or compliance-friendly compensation structure?
I think many financial institutions after the financial crisis put in place plans that I think Marshall and his colleagues at the Department of Justice would give the gold star to. I mean, there are very strong compliance-oriented compensation programs. I think the real question is are they being used in terms of the clawbacks? I think in terms of bonuses and the like, it's easier to withhold for compliance failures, and I would expect many of the folks here have processes where there are reviews when there's lapses in compliance to take that into account in year-end comp. But I think where the rubber meets the road is actually clawing back, and there are not that many companies that do actually try to go back and claw back comp. It's been done. I think the expectations that the department have give great incentives for the sort of ratcheting multiplier effect that Marshall talked about for the discount on any penalty plus the comp that you're able to claw back. But that's harder. I would say the other thing that's really hard is if you're a multinational company, you can't lawfully claw back in certain jurisdictions, and even depending on how comp is structured within the US, there may be pockets of types of comp that you can't claw back. So it's a complicated area. I think it's, again, great that the department is being transparent about what it expects, and I think having some way to incentivize companies that have done it is very helpful, because we haven't had that in the past.
And can I just add, I think sometimes you need to plan ahead. Now, if you operate in a jurisdiction outside the United States where you can't claw back, there's only so much you can do, other than maybe you can design some sort of deferred compensation plan that might enable withholding. But putting that aside, I think even in the United States, what we hear from frequently is, oh, our contracts aren't set up that way. And so now we're at, instead of at time 0 when we set up the contract, we're at time 10 and we can't unwind what our contracts say. So that's another reason we're trying to elevate the consideration here so folks can take a look. Is our program fit for purpose? Do our compensation systems and contracts permit clawbacks? And if they don't, maybe we should have them do so going forward.
And we're out of time, so please join me in thanking Mike and Karen and Marshall for sharing their insights with us this evening.